Arrivederci Roma, goodbye, au revoir. Si ritrova a pranzo a Squarciarelli, fettuccine e vino dei castelli.
Hello, this is Ryan Costello with Project Council Media. We're here in Rome at the DESI V Workshop, which is addressing the standards and best practices for using predictive coding, machine learning, and other techniques in legal review and e-discovery. I have with me at the moment Mr. Conor Crowley and Mr. William Butterfield. Conor is the founder of Crowley Law Office, and Bill Butterfield is the partner at Hausfeld LLP in Washington, D.C. And together they are the chair and vice chair of the steering committee to the Sedona Conference Working Group on Best Practices for Electronic Document Retention and Production. Gentlemen, thanks very much for being with us today.
Thank you for having us.
If they gave awards for the best titled paper presented at a workshop, you hands down would have won today's. The name of your paper was Reality Bites: Why Technology-Assisted Review's Promises Have Yet to Be Fulfilled. So just to get right into that, Conor, if I can start with you, can you give us a brief overview of why, despite sort of growing judicial acceptance, we just aren't there yet in terms of widespread adoption of technology-assisted review?
I think a variety of reasons, and I think when we talk about judicial acceptance, we're looking at a very small number of judges in a small number of highly publicized cases. So to call it widespread at this point, I think may be premature. With respect to the adoption by lawyers, there are a variety of factors that are hindering that adoption. One, I think, is ignorance of the efficacy of the technology, uncertainty about how to apply it, and also concern that if it is applied in the place of more traditional methodologies such as keyword searching or human review, which despite their failings have been accepted widely and have been used for a long time, lawyers may be forced to redo what they did using a more accepted technology. I think another aspect of that as well is that there has not been, up until now, a tremendous push from clients to apply this technology. Also, if you look at the way law firms in the US in litigation generate revenue, part of that is having lawyers basically review documents page by page by page. So putting in place a technology that minimizes the involvement of attorneys to an extent that was really inconceivable just a few years ago does, I think, upset the revenue generation model for a variety of law firms.
Mm-hmm. Interesting. Thank you. Bill, if I can go to you for just a moment. In your paper, you talk quite a bit about the importance of transparency and cooperation in the technology-assisted review process. Can I just sort of ask you to touch upon why that is so important and some of the complications and challenges that are inherent in that?
Ryan, I can think of several reasons. First, the technology is new. So anytime you have a new technology and lawyers being creatures of habit and skeptical of anything that's new, they're more apt to challenge that process. So I think as time goes on and parties become more used to using this technology, some of the challenges may go away. Second, however, is the concept of cooperation, which Sedona and others have championed for a few years now. And the view is that discovery is an iterative process, and it works best if the parties are maybe not fully transparent, but transparent enough to give each other comfort that discovery is being done correctly and the document productions are fair and reasonable. So that's second. The third, I think, is that it's my view that even though more transparency may be less appealing to some parties than their clients, the more the transparency, the more likely it is that a party can get sign-off from the opposing party Once that happens, it's less likely that there will be challenges to the process. So it's a balance.
Thank you. Thank you for that.
You're welcome.
Unfortunately, we were a little pressed for time this morning, so we didn't quite get to the entirety of your presentation. But as you both had mentioned, sort of if you're going to read one part of your paper, it would have been towards the end, where it was kind of the meat of the discussion, that you lay out potential disclosures, protocols, best practices for going forward in the increasing adoption of technology-assisted review.
Yeah.
Could I ask you to kind of touch upon those, maybe the big takeaways from that?
Can I start with the reason why we approached it that way? So the reason is we think that there is a balance here, and we took a shot at defining what that balance is. We're not advocating the full transparency approaching the Actos regimen, but we are trying to identify certain things that, if revealed, should give the opposing party enough comfort to make it less likely that they're going to challenge or be uncomfortable about the process. So what we did was we tried to determine what, I typically represent requesting parties who are most often plaintiffs in lawsuit. Conor's clients are most often defendants, so we thought if we can strike a balance with each other, perhaps that might be useful for others to learn from.
There is a real tension between the feeling of many lawyers that they should not be required to engage in this level of disclosure, and as Bill indicated, the fact that a certain level of disclosure may make this process easier. There are good, justifiable reasons why certain information should not be disclosed, but part, I think, of the evolution of the adoption of this technology is getting people to accept that certain information, if disclosed, may facilitate the use of this technology, and as Bill indicated, limit the extent to which it is subject to subsequent challenge.
So, a couple of examples. There are different methodologies. One is an active learning methodology, the other is a supervised learning methodology. So we think it's appropriate for parties to disclose the tool that they're using, how they're going to use that tool. We think it's appropriate for parties to disclose the document set or the information set upon which that tool will be used. For example, if the case has a lot of spreadsheets, or it has a substantial portion of the documents which were OCR'd from paper originals, some tools may not work as well. So it's important to know whether the tool is going to work on that type of production. Some tools may not work at all on that type of production. It's good to know the volume of the documents, both overall, the volume of the documents that are going to be fed through the tool, because certain tools require a certain volume of documents. The number of iterations to train a set, we think is disclosable. The custodians from whom the training will be taken, we think is easy to disclose. The parties' calls on what will be sufficient as far as precision and recall, we think can be disclosed. What we haven't advocated is to go as far as Actos, for example, and we haven't advocated disclosing the actual seed sets or the null sets. The seed sets can get into work product concerns. The null sets, the way the federal rules are set up, parties need only disclose and take part in discovery over relevant documents. The null sets are by their very nature not relevant, so one can argue that they're not subject to discovery.
And there is a real concern in certain types of litigation that providing non-responsive documents, whilst it is arguably giving some comfort to the other side with respect to the efficacy of the process, is also providing information that A, the requesting party is not entitled to, and B, providing information that may then form the basis of additional litigation, because they've been provided with information that may provide the foundation for additional claims that they were not yet aware of when they began the current litigation.
Now, I don't think we talked about this in our paper. I have heard some experts in the field say one solution if you have a dispute about those is perhaps a third-party neutral.
Yes.
So you take away the angst of providing seat sets and null sets.
Great. Gentlemen, thanks very much for your time. Really appreciate it.
You're welcome.
Thank you.
This is Ryan Costello with Project Council Media. Thanks for watching.